Welcome everyone to episode 7 of the Harry Sale Wealth Show. Today, my guest is Meghan O'Neil, who is a principal lawyer at O'Neil Estate Law, and Meghan's practice focuses exclusively on estate planning and estate administration law. Meghan, welcome to the show.
Thanks for having me.
To get us started, why don't you just give us a quick background about yourself, and then we'll move into some of the questions we have.
Yeah. So as you mentioned, rightly so, my practice is exclusively focused on estate planning and estate administration. And I've been doing this now for about 10 years and pretty much exclusively for 10 years. I got into the estate space very early in my legal career, even before I was a lawyer, as a summering student, as an articling student. My interest always lied in the estates space. And so I've been practicing almost exclusively in this area the entire time. Prior to opening my own firm, was first an associate and then a partner for a number of years at a Midtown Toronto law firm where I remain as counsel. And now, as you mentioned, have my own firm, O'Neil Estate Law, where I continue to do that estate planning and estate administration work exclusively.
Perfect. Yeah, that's what we try to do with our clients at Raymond James, just make sure that we have the estate side taken care of, especially with business owners. So when we work with somebody like yourself, it gets to the point where we can't do any more of the advice and we need someone to execute on some of the plans. So really what I'm trying to do here today is just ask you a few questions as it relates really more on a basis towards business owners. But one of the first places I really like to start is saying, what's the biggest misconception that Canadian business owners have about estate planning? And of course, when they get it wrong, what would be the real world cost?
Yeah, so I think there's a number of misconceptions about estate planning, and maybe the biggest one is not appreciating just how important it is. I think especially for business owners, I know my clients who are business owners and entrepreneurs, they are very busy, hardworking people that are in the zone of hustling to build their business. And so something like estate planning is something that can be easily overlooked in terms of how important that is. At some point as a business owner, and hopefully sooner than later, you're stepping back and thinking about, I'm building this, this business. And with that, the empire, the legacy that goes along with that. And how are you protecting that and preserving that and making sure that if anything happens to you in the case of incapacity, or when something happens to you in the case of death, which is inevitable for all of us, how are things going to be dealt with then? You don't want to spend all this time and, effort and diligence that you put into your business to leave, a mess for the people that need to potentially pick that up after you should something or when something happens to you. So it is really important that you have a plan in place for everything that you're building, that it can continue to however that looks like for you, which will vary from business owner to every business owner, right? It will be very different across the board in terms of what that would look like for them. But it's with an estate plan, at least you have control over what that looks like.
Yeah. And there's certain cases where people who might not have the estate plan or perhaps dying without a will might mean instead of governing who gets what, it goes through legislation instead. Maybe just paint us a picture. What does it actually look like for a business owner's family the day after they might pass away?
So a business owner's family in particular has special considerations given, the nature of running a business, right? But anyone who dies without a will, their estate is going to be governed by what we call intestacy laws that are set out in legislation, which is the Succession Law Reform Act specifically. Basically dictates if you die without a will, this is how your estate gets distributed. You have no control over how it is distributed. You have to look to the legislation and see what it says. And how it is distributed will depend on that person's survivors. And so whether they have a spouse, children, a child, multiple children, will all be informed in the split of how assets get split among the family members. And so for a lot of people, when they are married, their intention is that on the first of them to die, and I should say specifically in a first marriage, because this can be very different where it's a blended family situation. But in first marriage situations where the spouses also have children together, oftentimes a common distribution scheme will be giving everything to your spouse in the first instance, and on the second of you to pass, everything is divided equally among your children. If there's children, young children, then it needs to be held in trust for them until a certain age or ages. But that's a common intention of people. But if they die without a will, not everything is going to go to your spouse. Your spouse is entitled to the first $350,000, but then there's a split of the remaining assets among the spouse and the child or the children, as the case may be, depending on if there's more than one child. And if the children are under age 18, now we have to deal with how those funds are going to be held in trust for their benefit until they are 18. And the problems there are twofold, if not more, but two of the main ones I'll mention are that one, we don't have a will, so we don't have any trust provisions that say, okay, how are these funds for this child going to be managed until they're 18? When we're talking about a business owner in particular, now added, practical problems that may come in there, does anyone have authority to sign documents on behalf of the business? Well, if you don't have a will and where you've named an executor to step into your shoes in that regard, now you're going to have to wait all this time for the court to issue probate before anyone has authority to actually step into the shoes of the deceased on behalf of the business. Another issue that extends from what I just mentioned is that, if you have young kids, do you really want, do you want them to be inheriting shares in a private company when, they're whatever age they are? If you can imagine, the practical difficulties of now a 5-year-old becoming who is a beneficiary of your estate, now becoming a beneficiary of those shares. And also, again, it really comes down to that lack of control and in terms of being able to determine exactly what happens with the business afterwards, which if you don't put any of that in a will, you don't have any control over.
That's what we try and instill in our clients, personal or corporate. Just get that will done. It's always the bedrock of an estate plan. So glad you touched on that. Some of the people that I talk to would say, Harry, I just, I have this will. I want to make sure that I avoid paying probate tax. I really don't want to give any more money to this area that I don't have to. So in terms of business owners, what would be the most expensive mistake that you've seen someone make when they're trying to save on probate fees?
Yeah, sometimes people they get too preoccupied with the probate tax savings and they let that guide the entire estate plan. And it's really important that we look at your estate plan as a whole, including assets that have to travel through probate, assets that we can avoid probate on. Sometimes it actually makes more sense in the grand scheme of things to pay probate tax on an asset because of the trade-off that is more valuable than that 1.5% probate tax. A common scenario is where someone is trying to save that 1.5% and then they actually make a move in their estate plan that attracts more income tax. Well, of course, we want to avoid it where we can. And there's lots of situations where we can avoid the probate tax. And for example, for business owners, primary and secondary wills are a big one, which we can talk about as we go too. But in any event, there's going to be times where the probate tax and the cost of paying that is still going to be worth it for another benefit in the overall grand scheme of the estate plans. And so that's one example where I've seen where the intention appeared to be that they were trying to save probate tax, but they ended up really messing up the overall plan by doing that.
That's why people should talk to somebody like yourself or myself. Just ask the questions. Just make sure that you're saying, if you were in my shoes, what would you do? One major question that I get asked by a number of business owners is, how real is the risk that business creditors can actually come after your estate? And what would be the warning signs that someone needs creditor protection now?
Death, taxes are all certainties. A corporation is considered its own person, but nonetheless, the debts of the company have to be paid one way or the other. Ideally, the best case scenario is you have some form of liquidity. Oftentimes, this is in the form of life insurance where this will be achieved. But if the company does not have the liquidity to pay its debts, then it may have to sell off corporate assets in order to do that. And that may not be what the business owner would want to happen. Not to mention, if there's more than one business owner, let's say there's multiple shareholders, ideally you should absolutely have a shareholders agreement. When they die, what is going to happen with their shares in the company? Oftentimes there will be some type of buyout provision that says exactly how long the other shareholders have to buy out the interest of the deceased shareholder in the company. But then it becomes a question of, well, how are the surviving shareholders or shareholder going to be able to pay the estate for the value of the shares? And using life insurance for that is a very common strategy where the corporation will actually own the life insurance. The shareholder will be the life insured, and then the beneficiary is also the corporation, so that when that shareholder dies, the company gets that injection of liquidity from the life insurance proceeds to pay off debt so that they're not having to deal with potentially selling off corporate assets in order to do so.
In terms of business owners, a number of people would say, I have tons of money, I'd like to keep it in my family. What kind of tax maneuvers can I do? And they say this sounds like it's just for the ultra wealthy. But at what point could an average or regular Canadian business owner start thinking about an estate freeze or a family trust?
I would say more often than not, the advisor who will be, it could be your lawyer as well, but usually the accountant gets to it first in terms of recommending that. A lot of my family trusts are referrals from accountants who have advised their client, it's time for a family trust. Now we need a lawyer to draft it. And that's when they come to me because it is a really tax savings heavy strategy, right? So it might be when a business owner has children where they can now income split using a family trust. An estate freeze is coming into play more often later on, where the business owner they have all of the money they need in terms of their interest in the estate, and so they'll actually freeze their interest. They'll do a share exchange as well, so that the shares in the company that the value continues to grow in will actually be owned by a family trust. In that way, they can crystallize what their tax liability is going to be at death because there's a valuation that's done in the course of an estate freeze to determine exactly what the value of the shares are, both the preferred shares that the business owner takes, and then they can basically freeze that value in time, and they'll be able to, with that, calculate what their tax liability on those shares is going to be. And then the continuing growth of the value of the company will continue to grow in the common shares that will be owned by a family trust. And because of that, through owning them through a family trust, the business owner can be a trustee of that family trust and still maintain control over the use of or the distribution of the shares, and through that, the company. But it's something you need to speak with your accountant and your lawyer and your advisor, your financial advisor about, because it is a very complex strategy that we want to make sure we're implementing when it makes sense to do so.
And it's important to have that discussion about when does it make sense, because someone like myself can see where the business is going in terms of their wealth planning. So if I might say, hey, you're probably getting to the point where an estate freeze makes sense, but of course your advisor or your lawyer would certainly be able to recommend it. So at sometimes joint ownership can be good, sometimes it can be bad. A number of people might say, I'll put my assets in with my spouse or someone else thinking they're being smart. But what could be one of the worst case scenarios here? And what could be a downside of putting some assets into a joint ownership?
Yeah, this is a really common misconception that we can just add someone as a joint owner. It's an easy way to save probate tax. And it really is not that simple at all. It's an estate planning landmine because it can go wrong in so many ways. So, first thing first is that the intentional behind adding a joint owner is that someone thinks, well, by doing so, I'm going to save probate tax. And the reason they think that is because when spouses own assets jointly, there is a right of survivorship whereby when the one spouse passes, that asset that is owned jointly between the spouses is going to pass to the surviving spouse outside of probate. So that is true when we have joint assets that are owned between spouses, but that is for spouses only. And so if you have a joint asset that now a parent has put their adult child on, thinking, well, I'm just going to save probate tax by putting my kid as a joint owner on this account or on my house or whatever it may be, it doesn't actually work like that. Joint ownership is not the same in that regard. There's actually something called a presumption of resulting trust. And so with that, that means that the adult child will be known to be holding that asset for which they are a joint owner in a resulting trust for the benefit of the parent's estate. And what that means is that technically that does have to go through probate because the child was never intended to be the only beneficial owner. They were intended to hold it in trust for the benefit of the estate, whereby it is an estate asset. It's subject to that 1.5% probate tax. So that's a huge problem. And when we're talking about putting, a child on title to a home, that's another consideration there is that now that can compromise the eligibility for the principal residence exemption because that child, it may not be their principal residence. And if it's not, now you can't use 100% of the principal residence on the 100% of the property because one of the owners it's not actually their principal residence. That can be a huge income tax mistake that is going to far outweigh the 1.5% probate tax that you tried to save. And going back to, what you mentioned about creditors, whenever you add an adult child's title as joint owner to a home, to a bank account, an investment account, now you have exposed that asset to that child's creditors. A creditor could be, if that child ends up going through a marital breakdown, now that their spouse or soon to be ex-spouse could try to go after those assets that the partner is joint owner on, or the adult child in this example is a joint owner on. And so there's a lot more considerations that need to be factored in. And, there are limited circles where there can be useful ways to take advantage of joint ownership, but they are limited and you really need to get a estate planning lawyer, specifically someone who does have expertise in estate planning, because it is a complex area, to make sure that things are documented properly and that you're not just putting a child's name on title, not understanding the consequences of that.
So always ask first, and then we'll kind of review it with you. In the last section, we'll just do a little bit more of a rapid fire as well. So for takeaways and actual tangible action items that our listeners can take away, how often should business owners be reviewing their estate plans? And of course, what triggers should make them think to call someone like yourself or myself immediately?
Usually we want you to take a look at least every 3 to 5 years. It doesn't mean you're going to have to make a change every 3 to 5 years, but at least look at the documents, make sure everything reflects your intention. More often than not, there is some life change that happens in that span of time that when you revisit those documents, say, you know what, actually, I might need to update that. And it could be a very simple update. It doesn't necessarily need to be a whole overhaul of the entire plan, but it's worth looking at them at least every 3 to 5 years. As far as events that might trigger you to revisit the estate plan sooner, big ones would be, if there's a birth or death in the family, if any of the people you've named as executors or attorney for property, attorney for personal care, if they pass or if they are incapable or just no longer appropriate for the jobs, if there's some breakdown of your relationship with the people that you've named in these roles, you definitely want to revisit. It's not always practical to have someone who lives far away as an attorney for personal care, especially in the event of a medical emergency. And so if any of the people you've named do relocate, it's very important you revisit these documents then. It is important that if you plan on giving a significant gift to an adult child, we need to revisit your estate plan at that time, because typically a parent's intention is that if anything were to happen to them, that would be equalized. So the fact that they gave one child $500,000 and they didn't give the other child that same $500,000 yet, if they were to die before they can equalize it, they want to make sure that that will be equalized in the overall distribution of the estate. So we need to properly plan for that before the gift is actually made. And ideally, we would plan that with the use of a promissory note. More often than not, it will make sense for the parent to, and usually it's recommended that that parent actually structures that payment as a loan rather than an outright gift. And the intention is that it can provide against some creditor protection in the event of a marital breakdown. Not bulletproof, but worth pursuing. If you buy foreign property, that's another time you definitely need to revisit your estate plan as a whole. And with that, whenever you have foreign property, you definitely need to talk to your estate planning lawyer about not only having potentially separate wills in different jurisdictions, but separate powers of attorneys in different jurisdictions as well.
And speaking of property, a good real estate agent might say the biggest factors in a good house would be location, location, location. I know today with lawyers and financial planners, they might say the best thing for a person who has have documentation, documentation, documentation. So what specific documents should business owners have at the ready that most people might forget about?
Probate tax savings can be very significant by having 2 wills rather than one. And so definitely if you're a business owner, you only have 1 will or you have no will, you should certainly be getting a primary and secondary will. will. You also need powers of attorney to govern what is going to happen in the event you're still alive, but you're incapable. Now, who is managing your assets on your behalf? Other documentation could be even a note of wishes of business owners. They might not want to get into all of the nitty gritty within their will. They may want to leave some more flexibility within the will itself, but maybe a more appropriate place for some things to be expressed by the business owner would be like a very simple letter of wishes outside of the will, which should always be typed, not handwritten, and it can only note wishes. But business owner clients may prepare a letter of wishes that just lets their executors know, or their special trustee, the business trustee know, as the case may be, in the event that I pass, these are some of the people that you should talk to who maybe they would want to take over the management, or maybe they would want to buy the company. These are some potential purchasers, say, or, maybe it's okay, this person like knows all the ins and outs so they can continue to manage or whatever. It may be as simple as like, who's going to pick up the phone if something happens to me? So when it comes to things like that, some of those things can be achieved in a letter of wishes from the business owner that they can put together, again, with the help of their lawyer, to make sure that it's not in any way conflicting with the will, contradicting it, or inadvertently revoking it.
And just as a rapid fire final question, if you could force every Canadian business owner today to do one thing tomorrow to protect a family, what would it be?
I guess there's no surprise here, but it would be do your estate planning, talk to an estate planning lawyer. Things are just more and more complex than they used to be. And so it is important that you speak with someone who has expertise in this area so that there's not any missed opportunities. I really prefer where clients do involve their team of professionals in that. So it would be both you and I and the accountant that are all involved in the discussion of that estate plan to make sure that everything works cohesively.
So we'll head into 3 examples. I'll put the question up on the screen for everybody watching. So in this case, there's 2 business partners. Each owns about 50% of a successful company, which happens to be worth about $4 million. Partner A die unexpectedly, and partner A's spouse inherits the shares but has 0 interest in the business itself. Partner B can't necessarily afford to buy out the spouse, and the spouse wants cash for her interest in the business. She just might want to get rid of it and move on. The business is profitable but cash poor. Maybe just quickly walk us through this scenario and what should have been in place and what could be the options for partner B and for the spouse.
Yeah, so there definitely should have been a shareholders agreement here that laid out exactly what happens in the event that one of these partners dies or is incapable. Then what happens? How do we go about actually making sure that the estate of the deceased partner can be paid out their respective share interest in the company, and that by extension, the family member, in this case the spouse who's the beneficiary, is able to benefit from the deceased spouse's interest in the business. So absolutely, there should have been a shareholders agreement that said exactly what was to happen in that regard, and in conjunction with that shareholders agreement, it would have been having the life insurance in place to make sure that the company actually has the liquidity available, which will come through the form of life insurance proceeds on the death of that deceased partner, is going to get paid out to the business, so that then the company actually has the money to pay out partner A's spouse. So that is a very common strategy, and that in this case could have avoided a lot of trouble.
That's actually something we've recommended as well. So it's important to have that review with your advisor, with your insurance rep, with your estate lawyer. Just make sure that in any eventuality you've previously discussed it to just get aware of what could happen. In scenario number 2, this one we'll put on the screen again. It's a successful business owner has 3 adult children. One works in the business and is fantastic at it. One works in the business but honestly isn't really great at it. And one lives across the country and wants absolutely nothing to do with that business. It's really well run and it's worth about $6 million and represents a large portion of the owner's wealth. The owner wants to be fair to all 3 kids. What would be your advice for avoiding a family war after this person dies?
Yeah, this is a very interesting question, a very real world example, right? But there is no black and white answer. That is for sure. There's a lot of gray here because it's not oftentimes what it comes down to when we have a situation like this is that, what is is necessarily equitable is not necessarily equal, right? So let's say you have the kid who's in the business. Do they see themselves like taking over the business if anything happened to their parent? Or is this something that, they're happy to be a part of and they happen to be good at it? Let's say that child does want to inherit the business. There's obviously a disconnect in that. You can't just say, well, I'm going to give this child or the two who are already in the business, because the business is also 80% of the overall estate net worth, right? And so it does become a question, but it certainly may not be, an equal 1/3 split among all three kids, just to keep things fair, because again, what fair is not always equal. And looking at the type of asset that you're giving to each child needs to be factored into that. It's a complex conversation for sure, because there's a lot of moving parts to be weighed there.
I think it does come down to having the conversation. It's really important. Just, of course, having it with your family, having it with your partner, having it with your advisor, with your estate lawyer. Absolutely, just chatting it out before it happens so we can scenario plan it. Speaking of scenarios, this one's a bit of an interesting one. It kind of incorporates a lot of what we talked about today. So it kind of takes all the ideas you're talking about and compresses it down. So in this example, a 72-year-old business owner adds his daughter as the joint owner on $800,000 of bank accounts and the family cottage. And as we alluded to earlier, to save on probate tax, but also to help with bills and banking. So if she's on it, then it makes his life a lot easier. He dies without updating his will, and his will splits everything equally amongst his 4 children. So you can see the interesting part here. The daughter claims the money and the cottage are hers by survivorship. However, the other 3 siblings lawyer up, saying dad never intended for that to happen as indicated in the will, and he just really wanted banking help. What is the legal reality here, and what should have been done instead?
Yeah, this is a great example because it's very true to life and what we often see, and why this joint ownership can be a landmine, as we said, because it oftentimes leads to litigation wherever there's more than one child. So doing the joint ownership route can be a lot easier in the case of an only child, for which the adult child has a really close and healthy relationship. There may be scenarios where we can make use of that strategy, particularly if the client is very elderly and they expect that this plan is going to have to come into place sooner than later. Then there could be these limited circumstances, including where it's an only child, that it could make sense. Again, it would have to be very carefully, properly documented by the estate lawyer, because regardless, only child or not, the presumption is that that child is holding that asset, or those assets, in this case, the cottage, those accounts, in trust for the benefit of the dad's estate. And so legally speaking, that would be the advice. The interesting thing here that's definitely worth noting in this context is that there is also a disconnect in what the banks understand joint ownership to mean versus what in the law joint ownership is and how it will be treated in certain relationships in certain contexts. So again, when it's a spouse, it's automatic right of survivorship, which matches up with how the bank treats joint accounts. But where the disconnect lies is that banks don't recognize, or more often than not, the bank that you're dealing with will not pay any attention to the presumption of resulting trust. They will say, oh, okay, this joint owner, even though it was dad and daughter in this case, this joint owner died. So now the surviving daughter has access to all of these assets. And so where there is a daughter that actually, is going to try and take advantage of that, she's probably not going to come up against much pushback from the banks, at least. It's harder dealing with real property. She's probably not going to get much pushback from the banks, technically could deal with the real property as right as survivor. But in that case, you have the layer of having to go through a real estate lawyer we're gonna have to talk about, does the presumption of resulting trust here apply? When I say the presumption of resulting trust, another thing to note there that is applicable, irrelevant in this situation, is that it is a rebuttable presumption, meaning the daughter could say, no, I know that dad added me not for convenience, because he actually wanted me to have this asset. And so that's where now all of the siblings siblings are duking it out in court. And the other kids are saying, no, 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 you were only on those assets as joint owner for convenience. And that's where, your earlier example of documentation, any plan that we have to have the right documents in place. So again, there can be very limited circumstances where it could make sense to have a child as a joint owner, an adult child, but the presumption of resulting trust will still be there. And if we want to implement that strategy, we have to do it carefully with documentation that reflects the deceased intentions, and that will help us avoid the litigation that would inevitably happen in this example.
Well, Meghan, thank you very much for helping today. My 3 takeaways for today is really have the conversation as soon as you can with your family. Make sure that you're having that conversation ahead of time so that everybody's aligned if possible. Number 2, documentation. I know we went over that thoroughly over many times here. So make sure that you're recording what you can and getting all your documents in order. And of course, 3rd is speaking to a professional, such as your financial advisor, your estate lawyer, anybody else that we might have mentioned on this call today. I think really the underpinning theme here is have that conversation. So Meghan, I'd like to say thank you very much for your time today, and I really appreciate it.
Thank you for having me.